I'm Artie Holmes, the program supervisor for the Wage and Hour Division, and we have 4 other compliance officers throughout the state. There's Martina Phillips, who's in Post Falls, Marina Reynoso's in Caldwell, Anita Metro's in Boise, and Paul Withers is in Idaho Falls. So if you ever have any questions about wage payment laws of Wage and Hour, you can give any one of us a call, and we'll be happy to answer your questions for you. And we actually prefer you can call first because, sometimes a little bit of insight can help. So we'll go ahead and get started. And so this presentation is going to be over these main factors here, the things that Wage and Hour does administer, Idaho wage payment laws, minimum wage law, and farm labor contract and licensing law. But Wage and Hour does administer Idaho's wage payment laws, minimum wage law, and farm labor contracting licensing law. And with the farm labor contractor licensing portion of it, that's the only, I think, thing that we will issue some type of certificate for. The farm labor contractors are the only, industry that has to have that licensing from us. If there's going to be any other licensing, it won't come through Department of Labor or Wage and Hour. Only the farm labor contracting licensing information. And compensation includes, and it's kind of interesting because we'll get calls every day and from employees who don't really, know what compensation includes for wage claims. And so here's what we look into. Wages paid by minimum wage, regular hours worked, not overtime, unpaid commission, bonuses, vacation, PTO, and tipped wages. Now, each of these have their own little, pitfalls that we see every day. Minimum wage in Idaho is $7.25 an hour. Regular hours worked, not overtime. If a person wants to file a wage claim with us, we only have jurisdiction over the straight time. Anything that's going to be overtime falls to the U.S. Department of Labor, the Federal Division's Wage and Hour Division. Now, can someone file a claim with us for the straight time and they are also owed some overtime? They can, but if there is a determination, we will only make the determination on the regular hours, the straight time, and not the overtime. So if you have any questions about that, always, you can give us a call. We deal a lot with unpaid commission, bonuses, vacation, and PTO. These 3 are big. Commissions and bonuses, you really should have some type of policy set in place because it'll outline exactly when commissions are due, and it can even outline when they're due after separation. And the same thing goes with bonuses. You want to have your policy that addresses everything, how it's paid or not paid, or any deductions that will be made from it. Anything like that. Get that in writing and have the employee sign it. And if you have any questions, like you have a policy now, you can always send it in to us, and we'll be happy to read it and get back to you. Now, we don't want your whole policy because we won't have jurisdiction over your entire policy. The only thing we're going to look at are going to be any type of wage payment issues. So if you do want us to read it, just be specific at what you want us to read, and we'll be happy to do it. Matter of fact, we have one now. We got yesterday that has 91 pages. And so, of course, we're going to have to contact that employer and figure out which section they want us to go over for the wage payment laws. Vacation and PTO is another huge one for the state of Idaho. Vacation, PTO is something that's not required by employers. So, again, it all depends on what it says in that company policy, how it's accrued and how it's paid and how it's given, vacation and PTO. And we have seen employers' policies that simply say, if you quit without giving a 2 weeks notice, any accrued and unused PTO will not be paid. Something as simple as that. Or we have seen, if you quit without notice, you will be paid out a portion of the accrued PTO. Whatever you decide is totally fine. We just prefer you to have it in your policy and that the employee is aware of that particular policy. Tip wages. For some reason, sometimes an employer will take the tips. Well, the tips are the sole property of the employee, not the employer. And so we'll see those tip claims a lot. Matter of fact, we'll see them every day. But ultimately, the employer and the employee should be keeping track of not only their time, but also the tips that they receive. Some employers will pay out those tips on a daily basis, which makes it easier to just, pay it out and document it. But some employers will, pay their tips on the regular scheduled payday, which is totally fine. It's just make sure you keep everything documented.
We have one question already, Artie. Can you have a minor sign a loan agreement to deduct wages for something they have purchased through the business?
That's a tough one. We had this case that went all the way up to the feds and everything maybe 7 years ago, and it was that exact issue. The parent said that the minor son wasn't old enough to enter into a legal agreement for deduction of rate of wages because he wasn't old enough. So in this scenario, if they are a minor, make sure you have them sign it and their parents sign it as well. It may be an issue or it may not be an issue, but we always say protect yourself. Go ahead and have them both sign it. This is what it is. Now, if the parent doesn't want the child to sign it, well, that's fine. They don't have to. And just deal with what you have to deal with. But ultimately, anytime you're working with a minor, let the parents know what the pay rate is, when is payday going to be, if there's going to be any, just give them a copy of the policy. But because I think if the parents are informed, you'll have, I guess, less issue with the minor that's working for you. So to answer your question, it is to really, you have to get the parent's signature with it. But yeah, we did have that case. So wage payment laws apply when the employee-employer relationship exists. And basically all that is, it's like it says, if there's an employee-employer relationship, because we will get claims that are filed, and first thing we have to determine on every claim is if there was an employer-employee relationship, because if they were an independent contractor representing themselves as an independent contractor, then they have to go to another court like small claims or civil court or something like that. But if they are truly an independent contractor, we do not have jurisdiction. We only have jurisdiction over the employee-employer relationship. And if a claim is filed, of course, we have maybe 15 questions that we kind of go down through. How are they paid? How integral is this person to your business? Does this person have the ability to hire or fire someone else? Is this person being paid by the hour? Are they going to be paid by the end of the job? Did this person represent themselves as an independent contractor? Was there a contractor license signed? All those things to kind of figure out if there was an employer-employee relationship. We look into that, and we only look into work that is performed in Idaho. If the work was performed here, we have jurisdiction. And we will see Idaho employers who have a business, say, in Utah. And if the work is performed in Utah, then that employer has to abide by Utah's wage payment laws, not Idaho's. So whichever state the work is performed in, that's the state that the wage payment laws you'll have to follow. Wages due over $5,000. If the claim is for more than $5,000, again, we lose jurisdiction and they have to take them to court. Now, we do see this a lot where a person will be owed $5,100 and they'll tell us, well, just go ahead and forget about the 100 just so I can meet the statute and get the claim filed. We can't. If we know that the amount is there or during the course of the claim, documentation comes in that shows that the amount is above $5,000, we have to dismiss it through lack of jurisdiction. So the employer is a private sector, so we will only investigate anything that's private. We don't do city, county, state, anything governmental. It's just all the private sector. Okay, statute of limitations, 1 year. Some of the wages, if someone separates and they quit and you paid them some money and the person comes back and says, hey, I'm still owed some additional wages. Well, if they were paid anything after separation, they only have 1 year to file that wage claim. Now, if no wages were paid, then they would have 2 years to file that wage claim. So it's always beneficial for both the employer and the employee when you separate. If there's any wages that are due, get them paid within 10 days of next scheduled payday, or just get them paid and just kind of get that off, because you probably got to hire somebody else and get people, new people onboarding and things like that, and you really don't want to mess around with this. Get them paid and be gone. Okay, work at will. So there's no set length for employment. Either party may terminate with or without notice. The contract, policy, or union agreements may influence the employment relationship. It must be in compliance with Idaho's wage payment laws. And the one is that the second bullet, either party may terminate with or without notice. A lot of times people think that you have to give a 2 weeks notice. And correct me if I'm wrong, but I've never come across a statute that requires a 2 week notice to be given by the employee. So we do have that verbiage in people's policies, before you terminate, you have to give a 2 weeks notice. Well, that's in the policy that you guys are both going to abide by, but there's no law that says the employee has to give a 2 weeks notice. And again, anything that you have that's in your policy or your handbook or anything like that, get it signed, save it, and keep it, because you're ultimately required to keep it up to 3 years after that person separates. So yes, anything you have, get it, keep it. You don't have to keep folders. I mean, you can put it, God, I almost aged myself, almost at a jump drive, a floppy disk. No, can't put it there. Just put it on a little jump drive or something and keep it for up to 3 years after that person separates. It doesn't say how you're supposed to keep it, in what format, just that you're supposed to keep it.
We do have a couple questions, Artie.
Okay.
Since IADL does not oversee non-private, so they're a municipality, they're wondering if this webinar is geared towards municipalities or if it's really just for private sector.
It's for both, because we'll end up fielding questions from both. But the most of the business is going to be for the private sector. But if you are a city, county, or state, someone like that, an employer like that, you can still give us a call if you can't get a hold of the U.S. Department of Labor, because we do have, contact people. We can give you names, links to web pages and things, and maybe get your question answered. But yeah, we always suggest still give us a call. We may not have jurisdiction over it, but we can most surely get you to the right spot to get your questions answered.
Perfect. So Margie, it sounds like that it's up to you if you want to stay on, but we do have, certainly call us if you have questions and are having difficulty reaching the U.S. Department of Labor. The next one is, what do you do with unclaimed wages? What happens to the unclaimed wages?
If we have a wage claim and it goes through the process and we send it through our collections division. Now, when you say unclaimed, do you mean unclaimed from the employee? Never came to get the money from us? In that scenario, we do send the check. After 2.5, 3 years, we'll send the check to unclaimed property. And we'll also, at times, send the check back to the back to the employer with a letter with instructions on where to send the check. There's two little scenarios we have. And so the second one is the one we use the most. So if we had a wage claim, we collected the money, now we can't get a hold of the employee, they're gone, we'll continue to try for 3 years. If we don't, then we send it to unclaimed property. Either straight to them or we'll send it back to the employer with a letter asking them to send the money to unclaimed property.
Perfect. Those answer the questions. Thank you.
Okay, and back to your contract or policy and even union agreements, which of course the Department of Labor doesn't really get involved with the union agreements, but they are agreements that the two parties have, so they may come into play on any type of a wage claim.
A question would be, what's the retention period for employees? Not,
Retention period for employees?
yeah, we might need more to that question. Another question is, oh, go ahead. Oh,
So
retention of employee files is what they meant. Yes, thank you.
Oh, 3 years, up to 3 years after they separate.
Perfect. Another one, if you have an individual exempt from overtime and they're salaried and they are expected to work 45 hours a week, if they only work 4 hours, can you reduce pay? Or is the only option to reduce the time off bucket?
Okay, that's a tough one. So if they are salary and salary exempt, if they are able to work or come in and work, say, 2 hours of one day and say, hey, I got my work complete, no, you can't make any deductions from their wages. But if you have some type of vacation policy and you still give vacation time, you can tell those employees, okay, you're not coming in, but you are required to use the PTO bank first that you have accrued. When they start using that, if that depletes, then of course you're probably going to sit down with them and have a talk to them about attendance. But ultimately, there's only certain situations where times where you can make deductions from wages, and at the end of the day, if that person is able and available to work and the employer doesn't have work for them, if they work a minute, an hour of that week, then you have to pay them for that entire week. Now, there's times where you can prorate a salary-based employee, and that's when they're initially hired and at their end date. If they didn't work the full of the first week, you can prorate it to an hourly basis. If they don't work the full of the last week, you can also prorate it down to an hourly basis. But we do have a fact sheet we actually got from the Federal Department of Labor that we use extensively for these type of situations. So if you want to, I think it's fact sheet 17G and 17G, 17G and 17A, I believe, for the US DOL. If you don't have that link or you want those fact sheets, just let me know and I'll be happy to send it to you. And it's literally just one little paragraph that tells the times where you can and cannot make deductions from a salary-based employee.
If they have a company policy that addresses being able to do that, could that override?
The company policy can address using the PTO time to make sure they still get paid the same, but no, it wouldn't override the federal fact sheets.
Okay. Yes, we can get those. I was just going to say, well, there's another question and we can get those fact sheets out. And I said, yes, we could send those after the presentation along with the recorded version.
Yeah. All right. But yeah, those fact sheets are great. I mean, it'll tell you exactly when you can. And typically, when there's the salary-based employee, where we see a lot of problem is exactly that. If the person doesn't come to work, then they, make a deduction. And then we start asking questions. Well, was it due to your own personal illness? Well, yeah, but due to your own personal illness, you still can't make those deductions. So that paragraph is really the key to know when you can and cannot make those deductions. And we try not to deviate. Well, we don't deviate from it. And so I'd rather you guys just, when you get it, read it, and then give me a call. Because there's going to be certain scenarios each one of you are going to have. And rather than give you one blanket answer, it may not fit for your situation, but it may fit for someone else's. So get the fact sheet, give me a call, and we'll go in more depth into it for you. So Idaho law does not require vacation, holiday, severance, or sick pay, breaks, lunches, holidays off, pay raises, fringe benefits, and a limit to the number of hours an employee can work for employees under 16 years of age. Now, with these, we see these on a daily basis as well. So anytime you want to address non-payment of wages or earning holiday pay or anything or vacation time, it has to be in your policy. Now, the one that doesn't have to be in their policy because it's not going to have to be paid regardless is going to be sick pay. You don't have to pay the sick pay, but the vacation, holiday, severance, that's all going to be what it says in your policy. I'm sorry, severance, sick and severance, you don't have to pay those two unless it's in your policy. There's no requirements by law to pay those. So we suggest a lot of times when you put these type of policies together, include severance and sick because it's in there and your employees are going to be informed about it and they'll see it, and now you don't have the question, what about my sick time? What about my severance? Well, they should know to begin with, but if they don't, then you can just print off a copy of your policy and your acknowledgement forms and look right here. It says, we're not going to pay it, and you signed off on it on this day. And that's why we go back to documentation. Keep your documentation. Everybody should really keep their documentation. Lunch breaks and breaks and holidays off, although they are not required, but there's times when, we will suggest to employers, say, hey, if you're having a high turnover rate, you're not really retaining your employees and things like that, we'll ask, well, what do you do for lunch breaks? Do you have holidays? What's going on? If you want your employees to be healthy, happy, and do a safe job, sometimes they do really need to take those breaks. But if you're in an occupation where you don't believe that there should be any breaks, totally fine, because you don't have to. Just be aware that that tired employee is probably going to cause more accidents than the other person who's been arrested. Pay raises are not required, and fringe benefits are not required. So with the pay raises, anytime you give a pay raise, give it to them in writing. Let them know when it's going to start. At times we'll get claims where the employee says, hey, you promised me a pay raise. Well, the first thing we ask is, what day was that raise supposed to begin? Well, I don't know, they just said soon. Well, then now, person files a claim, and it's always back and forth, when all you have to do, if you're going to give a pay raise, say, hey, you may have an opportunity to receive a pay raise, and if you do, we will give you a specific date when that raise is going to be effective. That's off all that extra talk, because unless you give them the actual date when it's going to be effective, it's just letting them know that, hey, you do have an opportunity to get a raise, but if you do, we'll give you the date when it's going to be effective. Now, the same thing goes if you decide to make any deductions or reduce a person's pay rate. You can do it, but you just can't make it retroactive. So if my boss came to me today and said, hey, Artie, we'll have to reduce your pay rate, fine, they can do that, but they have to pay me everything, the work up till today will have to be paid at the higher pay rate from this day forward. Yes, it can be lowered. And we always suggest to the employee as well, in that scenario, anytime there's a pay raise or a pay decrease, reduction, get it in writing. It protects the employer and the employee. So even if the employee doesn't ask for it in writing, give it to them. Because if you don't, what's going to happen, potentially, if they get that, they're not going to see it in writing, they're going to give us a call. And then they're going to file a wage claim, and then you're dealing with me. You don't like dealing with me. So, just kidding. All right. Limits the number of hours an employee can work for employees under 16 years of age, and that's just child labor laws. And those may be changing here. We don't know exactly when, but we've got some wind that some of those laws are going to be changed. If they do, of course, there'll be a media blitz for you. So.
Well, Artie, as I'm sure you can imagine, we have 9 questions based on your last slide. So I will start those for you. So based on the slide that you just had up, please confirm that in the state of Idaho, we don't have to require an employee to take an unpaid lunch if they are working an 8-hour day.
Yes, that is true.
Perfect.
There's no law that says you have to give a lunch break. It's suggested that you do, but if you don't decide to, you don't have to. But if you do decide to give them, they have to be at least between 10 and 15 minutes long.
Can an employer require a lunch break if it is written in their policy book?
Yes. And if they have that in their policy book, the required breaks, and that employee is not abiding by the policy they agreed to, then you have it right there. That's just going to be basically not, abiding by the policy that they're aware of, and it could lead to separation and suspension.
Next question. If an employee does not pick up their check and does not leave a forwarding address or contact number, how should the employer handle it?
Okay, just make sure the check is made available at the usual place of delivery. So if they typically get their check by direct deposit it. If they typically pick it up at the place of business, have it ready at the place of business. It is their responsibility to come in and get it. Now, if you can't find them, we have what we call a reverse wage claim. If you spend a couple of weeks trying to contact an employee, former employee, you can't get a hold of them, you can give us a call, forward the check to us, and we will try to locate that employee for you. Which, if we can't locate them, sooner or later, we will send it back to you with that letter to send it to unclaimed property. But we will try everything we can to find that employee for you.
If it is a federal holiday and we require them to work on that day, do you have to pay them time and a half?
No, only if it's in your policy. That time and a half, or even have something called hazard pay and things like that. That's only going to be if it's in your policy, or you're doing some type of Davis-Bacon job.
When a salaried employee goes on vacation, is it okay to just pay the salary for the month, or do we need to break that down into the hourly wage for vacation time?
Pay it just the way it is. That one's kind of confusing. So they're on salary and they went on vacation.
Yes.
And the person used their vacation time, or they're not wanting to use their vacation time, or have they no vacation time left. That could be a tough one, because if they're going for 2 weeks, the first week you may just go ahead and have to just pay them out with their vacation time. And if they have any left for that second week, if they didn't come in whatsoever, they didn't perform any work, you wouldn't have to pay them for that week. And it's all going to get back to the reason why they missed. Was it due to their own personal illness, or their own personal illness, or something illness like that? Then you wouldn't be able to make deductions. If it's for other reasons, then you can make deductions, and that's why I say get fact sheet 17A and 17G, and get our phone numbers.
Perfect. Corey, if that doesn't quite answer your question, you can definitely call us afterwards. That was a pretty specific one. The next question, if an employee gets 5 days of PTO after 1 year of working with the company and they quit, are we required to pay the PTO out if they haven't used any of their days?
Depends on your policy. And so if I'm working there and I come to work with you, and as soon as I get there, I earn automatically, or you just give me 5 days of PTO and you put it on my pay stub. Once it's on my pay stub, the only way you can take it back is if you have that written permission. So if you gave me those 5 days and you have something in your policy that says, hey, if you quit without working here for a year, any accrued and unused PTO will not be paid. You just have to have some type of forfeiture clause in there for that situation. And we do see a lot of employers who just go blanketed any type of separation, whether quit, discharge, or layoff. Any accrued and unused PTO is not going to be paid. If that type of verbiage is in your policy, regardless of how much they have, you won't have to pay any of it out.
If an employee gets 5 days of, I answered that one. Just to clarify, exempt employees cannot be mandated to use PTO if they work less than 40 hours a week.
Unless it's in policy.
Okay. If an employee quits without giving notice, can you have a policy in place that the employee signs that says if you don't give notice, your final check will be reduced to minimum wage?
Yes. And we see that one a lot. We see if you quit without notice, your final wages will be paid at minimum wage, which is totally legal. They sign for it. You just have to have them sign for it when they initially come on. The problems we get is we see those type of policies coming in after the person was informed that they're being let go. So get that in writing when you onboard them. Get it then, not at the end, because the first thing they're going to say is, well, I signed it under duress. They didn't want to give me they're going to withhold my check unless I signed it. Whatever reason it may be, just get all that information when you do the onboarding.
What would be a reason for a pay reduction?
Reason for pay reduction? Honestly, it's totally up to the employer. The employer can say, hey, we're having a funding issue, so we're going to have to reduce people's pay. I don't know what reasons that employees have to reduce someone's pay, besides maybe someone's not doing a great job, maybe their work isn't what it should be. Whatever reason the employer decides, that's going to be the legitimate reason, and that's the reason we take. As long as you inform them. We don't get into if an employee says, hey, I just got my evaluation, it was perfectly fine, and now a week later they're reducing my pay. They can't do this because I just got this evaluation. The evaluation's great, but ultimately if that employer says, hey, we still need to reduce your pay rate, they can do it. You don't have to give them a reason, but some people are going to want a reason, and that's totally up to you of what type of reasons you give. But ultimately, I don't know of anywhere where it's required that you have to give them a reason.
It sounds like this employer has exit paperwork that needs to be filled out prior to the last paycheck. And so they're asking, what happens in that case if we have exit paperwork to fill out in order for them to get the last paycheck?
That you cannot withhold the paycheck for any reason. So if you have this process of employees who leave, it will have to sign all that exit paperwork. You can ask them to, but if they decide they don't want it, they just want their check, only thing you can do is give them their check and be done. You can't. There's no reason within the law to withhold a check for any reason. And we'll see that a lot too on uniforms, tools, equipment. He didn't bring back my shirt, so I'm not giving him his check. Well, we do call the employee and say, hey, just get the shirt back, and get your check. But if he decides they don't want to, ultimately, you, the employer, there's no reason to withhold the check. And then that person can probably file a wage claim and then seek penalties for not being paid on time. And the first question we're going to ask is, well, how come you didn't pay them? And if we get the answer, well, they didn't fill out the paperwork we asked them to fill out as they were leaving. Well, can't do that.
Let's see. The next one says if you have a remote employee and they are required to clock in, they choose to clock in and not out, or they say they were there but did not clock in or out. How do you handle that situation for payroll?
This is a tough one because if the employer is aware that the employee is doing work, then of course you have to pay him for that time. But since they're working from home, you got it half right. So you have to sit them down and say, hey, okay, when you clock in on the computer. If you take a break, clock out. If you leave, clock out. This is company policy. This is what you have to abide by. You give them all basically that information and just let them know, hey, if you fail to follow a known company policy, as simple as clocking in and clocking out, it could lead to your separation. And when it comes to pay, we can only pay you on hours that we know that we have documented that you worked. You clocked in at 8. Are you telling me you worked the entire time until 8 o'clock the next morning you clocked in? we'll know I forgot to clock out. Well, there's some trust here. And so that's why with those, I guess, people working from home, that trust level has got to be pretty high. And the standards that we, the employers, have to just let them know, hey, this is the process, this is what it is. If the process is not followed, it could lead to separation. Just go down the list with them. Or you can even just say, hey, you haven't been following company policy. This is the first occurrence. We're going to reduce your pay by $1 until starting today. And when you do that, people tend to clock in and clock out. At least I know I would.
In our policy and procedure booklet, we have it annotated that they must work 2 weeks beyond returning from their vacation time. Otherwise, we will deduct the vacation time back from the employee. Is this okay?
They must work 2 weeks beyond their vacation time, so they can't take their vacation and then come back and quit.
Right.
Ooh, that's a tough one. It's already earned, already given. Yeah, just without any other information, I would say yes. But there's going to be more information that comes in, but based solely off of that, I would say yes, it would be fine.
Okay. That could be one that you guys follow up with Artie afterwards.
Yes. Yes.
If an employee doesn't return work equipment upon separation, can we deduct the cost of the equipment from their final paycheck?
You can. If it's in your policy, your onboarding policy, just simply saying if you don't return company equipment when you separate, it will be deducted from your wages. You can do it. The only thing is, you can't reduce the pay below minimum wage. So you have to pay a minimum wage, and you can keep the rest to pay for your tools, equipment. It's not going to make you totally whole, but we have had employers do exactly that and make that deduction, go give the employee their check and tell the employee, hey, you still owe me, say, $2,000. How do you want to handle this? And the employee may just say, I don't know what they're going to say, but they may agree to pay and just let them know, hey, if you don't pay this, I'm going to send it to collections. If you don't care about your credit score, that's fine, but we do. How do you want to pay this back? But you can't reduce it below minimum wage. The only time you can deduct anything from a person's pay down to zero is if they were paid in error, basically by mistake. So if they were paid in error, then you can deduct it dollar for dollar and you don't have to have written permission. But everything else, uniforms, tools, meals, all that, if it's going to be taken out of wages, you have to have the written permission for it.
I'm not sure if you can answer this, Artie one. Can an employee start working without having their correct identification? If so, how long can they work if they don't bring in correct identification?
That's technically not wage and hour, but
Yeah.
we do get this question. And what we end up doing is just saying, hey, don't put them to work until you have their documentation. Person comes in, works for a couple hours, and leaves. You don't have the proper documentation. Wage claim is filed. Then the employer comes back and says, well, he didn't stay here long enough. He didn't give me a copy of his Social Security card, driver's license. He didn't give me any of his I-9 information. But yet you put him to work. The I-9 information and all that information says on their forms you have to have this field completed before you put them to work. So my suggestion is if they don't have that information, and I know you get busy and you have to get the job done, I understand that, but if you have someone that's, dragging their feet, not really bringing stuff in, I can't say don't hire them, I don't want to say that, but just stay on top of them and just be aware that if they aren't going to bring in this little bit of information, at some point there's going to be something else you want. So just a grain of salt.
I agree. I think we see that if they don't have if they're looking for work, they know what documentation they need. There's probably a reason they're not giving it to you. So just be careful. So lots of questions. We probably can can go on with the presentation, and we'll hold these maybe till the end, Artie, or do you want to take a few more?
Sure, maybe a few more.
Okay. This one I know we get a lot. If they get a paycheck advance, so a draw, and quit, can we reduce their final paycheck to 0 to retain some of that advance that's owed back? Or do we still have to pay them minimum wage?
No, if it's an advance, I'm sorry, advance and payment in error. If it's an advance and it's been documented as an advance, you can take it dollar for dollar. Advance and payment in errors.
So speaking of error, if payroll department accidentally overpaid an employee, they didn't notice for a couple months, is there a time frame that they can still collect those mispaid wages?
No. As long as it's documented, you can go back as far as your company will go, I guess. There's nothing in the statute that sets a time frame of how far an employer can go back on an improper payment.
If we have a sign-on bonus and the employee does not stick to their agreement and contracts, can we take that bonus out of their last paycheck?
Yes, if you have that written permission to make that deduction because they didn't stay long enough, you can, but because it's not payment in error, it's not, or an advance, you still have to pay a minimum wage and keep the rest.
Can a paycheck be less than minimum wage if the employee is paying back on an advancement?
Yes, if they're paying back on an advancement or payment in error, yes. If it's for any other type of deduction, no.
So if an employee has a charge account with that business, they can reduce the final paycheck to 0 to pay that account off.
Ooh. In those situations, it's a no because it's that charge account. And we'd have to see more information on that one because, how does the charge account work? So when I go in to use the charge account for a sandwich, is it just advancing me money from the hours of work? If it's an advance and documented as an advance, totally legal. But if it's just like a charging holding account and I have to pay for it on payday or something like that, then you have to have my written permission to make that deduction from my wages. And then you can't reduce it below minimum wage.
So it would be like a employee charging food and gas at a convenience store, right, just like a customer would.
Yes. So we have a employer, let's just say in Blackfoot, this employee makes $7.25 an hour, and the employee lets them charge food items from the store. So the employee made all of his charges, but of course you can't make any deductions from his wages because he's already making minimum wage. Any deduction you do is going to put him below minimum wage.
Perfect. The last question, and then we'll move on. I thought I-9 documents are required within 3 days of start date. I-9s are, but ID and that other stuff is, I don't have a time frame on that. So, okay, Artie, we'll have you go ahead on. Thank you so much for answering all those great questions.
Okay. And so now, hope this is where we left off, the employment relationship, independent contractor versus an employee. So the independent contractor, they have their independently established trade, temporary relationship, may hire others, may take on other work, and possibly a profit. So you guys can kind of just read through those. And the same thing with the W-2. Companies direct the employee's work. They're going to be there for an extended period of time, projected, may receive incentives paid by the hour or by salary, is required to work under a licensed individual, using the company's tools, materials, equipment. That last one, using the company's tools or equipment, that one fact right there tends to bleed over to the independent contractor side, to the employee side. And there's no, excuse or reason why, but typically, if we have an independent contractor and they do go to work for an employee, or they think they're an employee, they're going to go, well, I'm going to use my tools. Well, then now that employer goes, well, if you're using your tools, you must be an independent contractor. No, my tools are just better. So if you hire someone on, to do the work, make sure you give them all the tools to complete their work so you don't have that difficult conversation. Or get it in writing. So is there an opportunity for employers to pay youth less than 20 years old, less than minimum wage? Yes. And for us, we do have this, but for that first consecutive 90-day calendar days, we had one once here in Pocatello. What the place was doing, they were hiring high school kids every summer, and every summer they started them at $4.25 because they hadn't worked 90 days. Now, once the clock starts, it starts. So if I go to work this summer at that location, next summer when I come back, they have to pay me at least $7.25 because the 90 days started. So, and then this is another one that we do say, if your company is going to do this, let the parents know. Okay, minimum wage. Standard minimum wage is $7.25 per hour. Tip minimum wage is $3.35 per hour, and includes the tip credit. I don't know if we have a lot of tip-based employers here, but tips, they can get difficult, and that's why, again, it goes back to documentation. It goes to the employees, just document, document, document. So the employer is paying tipped employee $3.35 per hour as required by state law. Employer does not have to pay any more as long as that person earns $30 or more in tips per month. False. So the employer must ensure the employee is making at least minimum wage, $7.25 an hour. Tips belong to the employee and are added to $3.35 an hour. If the base wage with the tip does not add up to at least minimum wage, the employer must make up the difference. So if that person is on tips and I don't do a great job, I don't get any tips. If I don't bring enough tips to bring it up to $7.25, then the employer has to pitch in the difference to make sure I receive at least $7.25. I'll do better. I'll bust more tables. I'll get those tips up. Okay, hours worked. So non-exempt employees should be paid the agreed upon hourly pay rate, at least minimum wage for each hour worked, overtime pay after 40 hours in a 7-day period, and work suffered or permitted must be paid. And that's a tough one, especially if you have people working from home. If you allow, or basically, yes, if you allow someone to work, if they suffer and are permitted to work, and there's some type of work product, they're going to have to be paid for that time. Just kind of be aware if work is done and the employer is aware of it, paid. And overtime, it's based on 40 hours a week, and we get those calls every day because there's other states that do it by the day. I think it's California does it by the day, but we don't. We use the federal guidelines. Okay, hours worked. Rest break, usually 20 minutes or less, may be called back to work, counted as hours worked. Meal break, 30 minutes or more, completely relieved from work, not counted as hours worked. So if you are going to give those lunch breaks, you're not required to, but if you do, you have to follow these guidelines. Wait time. Now, for this is a difficult one because we will have sometimes an employer will tell an employee, okay, your shift starts at 8, but you need to be here at 7:45, logged on, ready to go. And typically that clock would start at 7:45, not at 8. And what we try to suggest to employers, if you use any verbiage like that, just let the employee know that their shift starts at 8 and you should be here ready to go, logged on, ready to go by 8. Now you didn't establish that 7:45 as the start time. 8 o'clock is still the start time. employee's responsibility to get there, be logged on, ready to go on time. Okay. Wait time, let's see, compensable, unable to use time for their own purpose. If they can't use it for their own purpose, it's going to be paid time. Use of time is controlled by the employer. If the employer is controlling my time that I'm supposedly off, it's going to be paid time. Not compensable. Able to use time for their own purposes, so I can go do whatever I want to do, go fishing, done deal. And completely relieved from work. But wait time, again, that's another one we get a lot of questions every day on. And so if you ever have any issues with should you pay or shouldn't you pay, just give us a call and see if we can work through it. And if we don't have the answer, we will look it up and find it for you.
Would going to a clinic for a random drug test be considered compensable time?
Going to a clinic, was the person instructed to go there, or did they go on
Yes,
their own?
I'm guessing they need to take a random drug test for work.
Yes, it's going to be compensable time. If the employer is requiring them to go take that random test, we do see this on that scenario. If they have that in their policy, just simply say that any random drug test will be paid at minimum wage. That way you can, at least pay $7.25 and not to have to pay them $15, $20 an hour for the drug test. But if that person decides just to go get the test on their own, well, of course, no. But if they're instructed to, then yes. Training time. And we get this one a lot, too. We do have some employers who will pay a lower pay rate for any training, which is totally legal. It's in their policy, letting employees know that any training is going to be paid at $7.25. And that's how some employers can save money sometimes, because they do have to, pay for the training. So meetings, lectures, or trainings for the employer's benefit. So only way it's not going to be compensable is if it's outside of regular hours, voluntary, not job-related, and no employer work is performed. That's the only time it would not be required. And this is another big one, especially now we got all this construction going on, travel time. Between job sites during a normal workday, paid, not compensable, ordinary home to work. So home to work, work to home is not compensable time. Between the job sites would be compensable time. And sometimes what you'll see is I have a construction company, there's 4 of us, and I'm driving the vehicle, but we actually have a job site in Blackfoot. So we all get there to the job site. I'm the only one driving. They just jump in, my coworkers jump in, and I drive to the job site. Once we get to the job site, clock starts for them. I'm the driver of the vehicle. My clock started when we all got in the car. Now, someone else could drive back if you want them to, so they can get paid that portion, but then I wouldn't get paid the drive back time. So, but if you set a job site in a different city, that new city becomes a job site, and you don't have to pay home to work and work to home. But if they come to your place of business, they get in that vehicle and just take off, no pay. If they get to your place of business, they start loading the van, doing other work, getting things prepped, loading the van, doing things like that, then that's going to be work time, and it's going to be, now when they get in the car and leave, it's going to be work during your normal work day. So typically, if I have a construction company, I'm just going to simply have 1 or 2 people. They're going to load the truck, they can get everything all ready, and then the next morning when we go to Blackfoot, the other 2 employees are just going to show up, we're going to jump in the truck and go. Any questions on that? Because that one can get tricky sometimes.
We have some questions in general.
Okay.
So if an hourly employee needs to travel for work, do they stay clocked in and submit mileage for reimbursement?
If they're traveling during their normal workday, yes. The mileage reimbursement, that's up to the employer and their policy, because it's not required.
If an applicant is being sent on a drug test before we hire them, do we need to pay for that time?
No. As long as everything is before you hire them, you do not.
If I send an office staff employee to work at another office, do I have them clock out or stay clocked in?
If they go to that other office first thing in the morning, they just get there and clock in. If they come to the office here, they would clock in and then drive, because then it would be working between the two buildings.
Let's see. If we use a time clock system and the team member did not clock out on a few days during the pay period, then the team member separated and have not communicated their clock out times for these days, how do we pay them for this? And do we go off what they were scheduled to work?
You pay them the undisputed, any amount that you know that they worked, pay them. So that way, if the person does think they've been shorted, they can file a wage claim. And the actual initial burden of proof is going to be on them to prove they worked the hours. You've already told them you need to clock in. This is the process of clocking in, clocking out. This is what you're supposed to do. If they don't do it, you pay them based off of what you have recorded. Because again, both parties are obligated to keep track of time. So if that person doesn't put their time in there, you pay them something, whatever it is that you know that they worked, and then the rest is going to be up to that person to file a wage claim, and it's going to be their burden to prove. But the key thing is pay them for what you have documented.
Would employees traveling to a trade show out of state be paid for time traveling on a plane the whole time?
Oh, that's a tough one. If they get on that plane and they make a phone call, open up a laptop, even at the airport, yes. This one, these definitions come from the Federal Department of Labor, and what we do on this one is basically we get the scenario and we go around and we get it figured out with the feds, because it sounds like they're all the same, but there's always something just a little bit different. And in this scenario, yes, based off what I'm getting, if that person opens up their phone, does any work? Yes. Opens the laptop? Yes. Because if I get sent to California for training or whatever it may be, when I leave the airport here in Pocatello, I'm not being paid because my new work site is going to be in California. When I hit California, that's when the clock's going to start. But if I'm here, I'm in that airport, I make a few phone calls, I open my computer, now that clock's going to start.
We have.
The phone was made.
Go ahead. Sorry.
We have different scenarios. What the feds do, and so yeah, if you have that question, give us a call, because sometimes we want to do is make sure it's right one. And so what I'll do is I'll send it out to the rest of the compliance officers, then we'll contact our federal contacts, we'll get an explanation, and we'll get back to you. An hourly employee is traveling to your paid training in Portland. They leave at 7 p.m. on Thursday and return Saturday at 2 p.m. Does the employer have to be paid for that Saturday's hours? Department of Labor doesn't include travel away from home outside regular hours as a passenger or an airplane, train, boat, bus, car. But you must count hours worked on regular work days and work hours on non-working days, weekends, and holidays. So those are the tough ones when you have people that have to go out of town and travel. Overtime versus comp time. So time worked in excess of 40 hours in a set work week, 7 days, consecutive days, 24 hours, may begin on any day, any hour, but most employers use Sunday through Saturday or Saturday through Sunday for their 7-day period. Pay is not less than 1.5 times the regular pay rate, and comp time is only made available to government agencies only. So Comp time is always a question. Is it comp? Is it flex? What is it? Well, if I typically work 8 hours a day and I'm a government-based employee, if I work 10 hours today, I can work, 6 hours tomorrow. And so we kind of can do that, but it's not going to be made available to non-government entities because basically you could have your employees do this and basically skirt overtime. So comp time is only going to be made available to government agencies and not to the public employers, I guess. Questions? Exempt, non-exempt? Exempt, of course, exempt from overtime. Non-exempt, eligible for overtime. And typically it's just the salary-based employees that the ones that are going to be non-exempt. Exempt. So for a salary-based employee, they have to get at least $684 per week gross. The qualified job categories: executive, administrative, professional, computer, outside sales, and typically manual labor jobs do not qualify for exempt status unless that person is some type of, crew chief, manager, or something like that. And payment of wages. So regular set pay days. That's one thing that we do like in doing this job is 99.9% of our employers, they do have their set pay days. And all these methods for paying, I think we do a really good job in our state of getting people paid. So if you have any questions about payments of wages, just let me know, and we'll be happy to assist you any way we can. Let me go back, though, for really quick. Because it's the pay card. Because what happens is we're seeing a lot more employers use pay cards to pay their employees. You can do that, but if that person at any time decides they don't want to use the pay card anymore, then you have to, go back. Right there it says must be voluntary. So if a person is receiving a pay card or direct deposit and they think, okay, I don't want this anymore, then you have to go back to the 5 paycheck or even cash if you want to. Because it can't be required. And then with the pay card, initially, what employers were doing, if they didn't use their pay card on payday just to take off all the cash, if I started using it as if it was a debit card, well, then now I'm getting charged to access my pay, which the law says you can't charge your employee for your pay. So the only real way around it was you are going to use a pay card, and a person wants to think they're going to use it as if it's a debit card. Give them specific instructions when you pay them. Do it for like maybe 4 or 5 pay periods. Just put a little flyer in there. It says on payday you must, take all your wages off this pay card. If you use it as if it's a debit card, you will be charged and not the responsibility of the employer. Put that in both. So now, if that person does decide to use it as a debit card and they file a wage claim, they were informed, they know, and they decided to do it anyway. So just got to be careful with that. And the last thing we have with those pay cards are pay stubs. Employees are getting links that they can go online and print off their pay stubs, but sometimes they aren't. If they can't connect with the link or they don't have a password or whatever it may be. So if you do get those links, don't just send the employee the link and be done. Send them a link, give them instructions, show them how to get their pay stubs. Matter of fact, have them print one off and show you that they can do it. But now, if we do get a claim and they say, hey, I will never receive my pay stubs, and then, first question we're going to ask is, did you ask for assistance? Well, yes, and no one helped me. Well, no. Well, you will have the documentation to clearly show that you did try to help them. It's nothing that you're doing that's preventing them from getting their pay stubs. It's their own doing. So in Idaho, upon termination, how long does an employer have to pay the employee's wages? Okay. I hope you guys are still there. I hope this is still working. So upon termination by either party, all wages must be paid the earlier of the next scheduled payday or 10 business days. Now, if there's a written request, then the wages have to be made available at the usual place within 48 hours. So the question comes, what is considered to be a written request? We accept text messages and the emails, and even fax if it can be confirmed. So if an employee sends you a message via text requesting their final wages, and there's a response to the text, then yes, it's going to be considered a written request. Same thing goes with the email, same thing goes with the fax. If there's confirmation, that's when it's going to be effective. If the text message or email is sent and there's no response to it, then the claimant would not have met their burden of proof to show that they were not paid in time, because there's no response, and we would go back to the 10-day rule. So 10 business days over the next pay period, whichever is sooner, unless there's a written request to receive your wages within 48 hours. Now, we do have those questions sometimes. A person will give a written request for the final wages, but they won't put 48 hours on there, and sometimes the employer will come back and say, well, they didn't say they wanted it in 48 hours, so we didn't get it to them in 48 hours. Well, no, any written request, they don't have to put 48 hours on there. If they make a written request, we don't have to use the 48-hour criteria. And mind you, we do tell this to the employees as well. I mean, we tell both parties the same thing, so just be aware. It's a 10 business days or 48 hours, and text messages or emails, if there's a response, we would consider them to be valid. And penalties for final wages being withheld willfully. So the main three criteria is willfully, arbitrarily, and without just cause. Final wages were withheld. And those three things right there, willfully, arbitrarily, and without just cause. And that comes with working with the compliance officer and the department. Just, if we call you and you say, well, our bookkeeping division got hacked, and we're about a week behind on paychecks. That's why we didn't pay on time. Well, for us, I don't think that would be willfully, arbitrarily, don't just cause. You had nothing to do with it. It's things that are outside of your control. Now, if we contact the employer and the employer comes back with, well, they still have my certs, I'm not going to pay them, well, then that's going to be willful, and we probably would have to look into the penalty of $750. Now, $750 is the maximum amount that we can penalize, but if a claim is worth, let's say, $300, the penalty won't be $750. It would be a like amount, unless there were some other egregious things going on with the claim. It would never be $750 for a $300 claim, $200 claim, so forth and so on. So if the claim is ever worth less than $750 and there are penalties, it's only going to be the like amount, again, unless there's some other information that's contained in there. Okay, withholding from wages, advances. So if you give an advance, you may deduct dollar for dollar without written authorization. Overpayments, you may deduct dollar for dollar without written authorization. Loans, these are tough ones. We do see these loans, and again, get it in writing. Written signed agreement to deduct from wages. Agreed upon amount payment must meet minimum wage each pay period. So we do see it. Person gives us written permission to make those deductions. They sign for it. It's legal. But overpayments and advances, those are the main two. If they're in an advance, an overpayment, which is payment in error, then you can deduct a dollar for dollar. No written permission is needed. Withholding of wages. Withholding of wages. You cannot withhold or divert any portion of wages unless you're required to do so by state and federal law, written authorization from the employee for a lawful purpose. Examples, uniforms, shortages of tills, training costs, things of that nature. Now, when we first started looking at this particular statute, it says written authorization for the employee for a lawful purpose. And we sent this one up to our attorneys, and basically what they came back and said was anything that they sign for is going to be a lawful purpose. If it's not signed for, then it is unlawful. Made it easy for us. So anytime you have some deduction or anything, if it's signed written permission, is now a lawful purpose. Withholding of wages, minimum wage compliance exercise. Hourly rate, $8 an hour, hours worked. So $8 times 30 is $240. Uniform cost, $30. So we take out the 30, leaves work with $210. Minimum wage is $7.25 times 30 equals $217.50. So, and they do it. Did it meet minimum wage? I guess you can see that it would because of the X's down there, so kind of rhetorical question. So, all right, I'll go with the next one. Okay, if worker is caught stealing $400 from the till, you fire the individual and report them to the police. Can you withhold their check to cover your loss? Again, you're going to need that written permission, that written authorization from the employee to make deductions from the wages. And we do recognize and we do understand, and the person may even admit to it. But ultimately, if you don't have that written permission, you can't touch the wages. Reduction of wages must give notice of pay reduction prior to any work being performed, in writing if requested, and we still suggest that no matter what you do with the pay, whether you're going to give a raise or a deduction, whatever you do with it, changing from hourly to salary, whatever you do, give it to the person in writing as well. Record keeping, maintain employment records for a minimum of 3 years after termination. And again, I think I said that earlier. There's nothing really in there that says what format. It just says you're supposed to keep them. So put them on a jump drive or something like that and just keep everything for the 3 years after separation. At the time of hiring, you must provide pay rate, pay days, and in writing, especially if they request it. And so what we're saying or suggesting is just go ahead and give it to them before you can get the request in writing. So for wage and hour assistance, we'll have the Idaho Guide to Labor Laws. We have the required posters at our home webpage you can print off, frequently asked questions, and we will review employers' labor policies. And that's kind of one that's kind of misleading. We don't read your entire policy. We are only going to be, I guess, interested in wage payment statutes and issues. That's it. Workplace conduct, things like that, that's going to be thinking unemployment insurance or someone like that. How someone's being treated on the work site, that's not going to be us. That's going to be, maybe the Human Rights Commission. So if you do send it in, just let us know which section you believe is going to be pertinent, and we'll be happy to review it for you. Disclaimer, the Wage and Hour Division is providing this presentation solely for the educational and informational purpose. The information and related materials are presented as a service to give the public access to information on the Department of Labor's wage payment laws. The Idaho Code statutes are the official source for our wage payment laws. They can be found on our official website of the legislature. Okay. Well, if you have any questions, let's shoot.
Okay, so great information. We are getting close to time, but we will stay on and answer these questions. So if you can stay and listen to the answers, that's great. We have, as I told you guys at the start, this is always our most popular and I think consumes most of our phone calls during the day at Department of Labor are these great questions. So thank you for being great about asking questions today and letting us get through the presentation and holding some of these to the end. I apologize if yours was held to the end, but we had a lot of good information to get through. So I will start with the questions. Is there anything wrong with keeping previous employer personnel files longer than 3 years?
No, I don't think so.
We're a caregiving company. Oh, go ahead.
No, I was just thinking, as long as you don't get rid of it sooner than you're supposed to, I think you're fine. Perfect.
We're a caregiving company. If the client cancels, but our caregiver, our employee, still goes over to the shift, do we pay them the full shift, part of it, none of it?
The client cancels. You would still have to pay them their agreed-upon pay rate. Are they being paid like through billable hours or something like that?
Typically, yes.
Okay. Yeah, you'd have to pay them the same pay rate.
If we have a handbook stating the employee needs to take a 1 hour lunch break, and if the employee chooses to take a break less than 20 minutes, do we need to monitor that to ensure that we are paying for the employee for that time?
Yes, because if they come back and they're working, that's going to be compensable time because they're performing work, which at the end of the day could impact overtime.
I have an employee that works from home. Sometimes they clock into work in the morning, but then they decide to drive to work in the afternoon. So it's not required. They're choosing to come into work on the afternoon. The drive took 25 minutes. Do we have to pay them for that drive time?
No, I would think that would be their break time that they're using to come in because they're making that choice to come in. They're not being told to come in. But you probably need to sit down with those individuals and just have a conversation with them on what you expect.
If an employee is hurt on the job, do you pay them for the time at the doctor? Also, do you have to pay them for the remainder of the day if they get hurt?
You pay them for their hours of work. If they have any PTO they want to use or anything like that, of course, they can use that if they want. But no, just paying for their hours of work, and then if they are injured on the job, I'm thinking the Industrial Commission would kick in for that to say what else needs to be paid for injuries and stuff.
I have an employee who is on call for 24 hours, but only works at a physical location for 8 of those. But they are on call via phone, to possibly come back in. With compensation, or what compensation should I pay that employee for on-call hours, if any?
Yeah, for that, I was asked this question a couple of years ago, and my answer was basically the same. If I have a person on call, I'm going to pay them, let's say, a minimum wage while they're carrying the phone. Once you're carrying the phone, you're getting to $7.25 an hour. If you pick up the phone and doing the work, you're going to be paid at your normal pay rate. If they are on call, you're restricting their access to go do what they want to do, so it's going to be compensable time. Now, and another part of that could be if it's just the one person that's on call or the 2 people. So if they try to call me, they can't get me, and they call someone else, and there's no big deal, no ramifications, I don't get written up, you don't have to pay me. But if there's some type of consequences for me not answering, then that's going to be restricting my duties, and then you would have to pay for it. So it's going to be minimum wage at least for the on-call time.
Are exempt employees made exempt by company rules or by us at the state?
By the state. And there, like I said, those fact sheets, it'll give you all the types of positions that are out there that should be usually salary, and it gives you a breakdown on all of them. There's links to it.
If my employees are salaried, can we require them to clock in and out, but then pay salary, or regardless of their hours, but then pay salary, or regardless of their hours?
Salary. Yeah, you can pay them by salary and still have them clock in, because ultimately what's going to happen, if there ever is some type of discrepancy with wages, first thing we're going to ask for, first thing the Fed's going to ask for, are going to be hours of work. So no, but you will get those, some salary-based employees will fight it. They don't want to put down their hours. They don't know why. Just, hey, you're being paid on salary. We get it. We're not making any deductions. We just want to keep track of hours worked. That's all we're doing. So Yes, you can do it.
If an employee is remote but needs to travel to the office for any reason, would they clock in for travel since their normal place of work is their home?
That's a tough one. So are they being asked to come in, or are they just coming in on their own?
Sounds like they need to travel to the office for any reason. So, yeah, let's assume that they need to come in.
Yeah, it would be compensable time. Yes.
If you advised and sent instructions for drug testing before being hired and the employee did not make time to do so before hire, would we still need to pay them for their drug testing time?
If everything was before hire, they aren't employees yet, so no.
When do we have to pay holiday pay?
Well, holiday pay is it's not required, so whatever your company policy is, or whichever, yeah, it's just going to be off your company policy. I know there's some federal guidelines for holidays, but we don't have any ones that are required from Idaho, so.
This is a salaried position question. If they, to qualify for salary position, are you required to have a direct report?
No, not that I'm aware of, no.
On the exempt
At some
salaried,
point,
oh, go ahead.
because at some point, unless you're the owner of the business, everybody has to report to somebody at some point, I believe, so. Okay, next question.
On exempt salaried employees at that $684 per week, can that include tips?
Mm-hmm. Well, typically, you won't be a tip-based employee if you're receiving salary.
Mm-hmm.
So that one I would have to say no, because if you're a salary-based employee, you're not going to be a tip-based employee. And so if I'm working in a restaurant and I'm the manager of the restaurant, I'm being paid by salary. That takes care of everything. And then I'm running the front of the house, which doesn't receive the tips anyway. So no, you would just have to pay them their salary.
Can we decrease wages based on performance or other reasons?
Yes, you can.
Yeah, we went over that. If regular payday falls on a bank holiday, but the business is operating, does pay have to be offered the next day, same day? What happens on bank holidays?
If it falls on a non-work day or bank holiday, they should be paid the preceding day. But if they're not, if they're paid the following day after the holiday, technically that's still going to be legal, because if a person files a claim, we can't penalize the day they were due or the day they were made available. And so there's only days in between. And in that scenario, there's no days in between. But if the holiday falls on a non-work day or payday falls on a non-work day, they should be paid the preceding work day.
When a written request is made for payment within 48 hours, does that include weekends and holidays?
No. Business days.
Let's see. Can a garnishment amount be more than the net check? I think you answered that after they said, or after they said it, but.
No.
Let's see. If all employee purchases are run through an advance account and pooled with outstanding employees' wages for deduction and those purposes, does there need to be written agreement as well?
Yes.
Let's see. Yes, we are going to, just as a reminder, going to have this presentation sent to you guys by email address. If an employee requests payment within 48 hours, we already answered that one, sorry. Let's see. Do we need written deduction on any deductions, or can we have an employee sign a blanket deduction for all payroll deductions upon first day of hire?
I mean, you can have them sign a blanket one, but it's going to have to be specific to what they're deducting for. It's going to have to say at least, shirts, T-shirts, whatever it's going to be. I don't know of any just blanket deductions. It has to be specific to something that you want to deduct for.
So just to clarify, those on salary are determined by state law. Because that weekly salary threshold is quite low in today's world, we have many admin assistants that gross more than that, $684 a week. Wouldn't admin assistants be considered to be salaried position according to state law?
Yes, they would. And we do recognize that. And it's actually the feds made that criteria for the 684, because before that, I think it was like 525 or something like that. And they went up to 684.
Yeah. At time of hiring, can we just state that paydays will be monthly, semi-monthly, etc.?
Yes. The statute is basically you have to pay at least once per month, but if you alter that, you have to pay at least once every 15 days.
So are we out of...
You pay sooner.
Oh, yeah, okay. So are we out of compliance if we pay our admin assistant an hourly rate, not on salary?
No. That's a choice, you guys. That's an agreement you guys can come to. You can say, okay, I'm going to do the work based on hourly pay rate, or you want to be salary. And if you guys choose to go hourly, you're totally fine.
Can you charge an employee the stop check fee when their paper check gets stale dated and needs to be reissued?
You can, but again, you're going to have their written permission to make that deduction from their wages. I don't know how you charge them if are they still working for you?
Must be, yeah.
Yeah. So yeah, if they're still working for you, just if you have it in writing that they give permission for any stale dated checks to be $10 to be deducted, you're totally covered.
Can you have different set paydays for different categories of employees? For example, regular staff get paid on this date and admin gets paid on a different date.
You can, but that's just a lot of work for your bookkeeper. But yeah, you can.
Can we require our salaried exempt employees to clock in and out if they leave during the day for an appointment, like a dentist appointment?
Yes. But that's the thing. Any time you say salary-based employees, that salary-based employee doesn't want to keep track of their hours and their time. So just always explain it to them. Yes, you are a salary-based employee, but we still keep track of time. That's all we're doing. We're not saying anything wrong is happening. We just need to be on top of our budget and keep track of the hours people actually work.
Perfect. Few more. These are great questions. Are we required to offer a paper check?
Well, you mean only a paper check? So you can offer pay cards, debit cards, things like that, direct deposit. You can. But again, so I guess you are required to. If I say, yes, I want direct deposit or a debit card, then yes, you can do it like that. But if I come in and say, I don't want that anymore, then yes, you have to give a paper check.
For employees on salary, how do we handle sick days? We do not have a paid sick time off policy, just vacation. Should we just change the vacation to be PTO? Currently, we have them use their available vacation days for sick and personal. Then it is unpaid if they have none left. We offer vacation after 1 year of service. So do you suggest a generic PTO or how to address PTO if they're sick?
Yeah, I would separate the two out, separate out PTO accruals to vacation time and sick time, especially with a salary-based employee, because if they're on personal illness, then you can't make any deductions from their wages anyway, but you could take it away from the PTO or sick time accruals that they have.
So they're saying they don't offer sick time though. So what happens when they are sick and they only have vacation or?
Oh,
and they're on salary.
You can use that. Yeah, then you can use the vacation time to make it up. As long as they still receive the same amount on that pay period, you'll be fine. But I would suggest to update your policy to include the two words.
Okay. And then if they run out of vacation time, so they have nothing left to take, but they still get sick, but they're on salary, what happens?
No deductions. It's their own personal illness.
So they don't have to pay them for it?
No, they do have to pay them for it.
Okay.
Employees
Perfect.
on personal illness.
Okay. Can we require salaried exempt employees to clock in and out if they leave? Oh, we answered that. I am so sorry, you guys. There's so many questions. Follow up on exempt punching out for appointments. Can we deduct the missed time from their vacation time if they don't reach 40 hours?
If it's in your policy, heck yeah. If it's outlined that's what's going to happen in this situation, you should be good to go.
We have answered a lot of salary questions. So they're asking, are people confusing an exempt employee with a salary employee? Aren't these two different things?
I think what happens is when you say salary, we always say salary exempt. And the exempt part is just being exempt from overtime. So you're right, there is some confusion a lot of times. But yes, your salary-based employee means I'm the 684 and exempt from overtime. And sometimes people will just say, well, I'm exempt. Instead of saying I'm a salary-based employee, they just say I'm exempt. I don't know, but it can get confusing.
We pay people for travel time if they travel during regular working hours. If they travel on the weekend, then we only pay them if they answer emails or open their laptop to work. Is there a limit on the time we pay them? Do we pay them for just the hours they actually doing the work-related stuff? So this is kind of the add-on to that original question we talked about.
Yeah, just you have to pay them for the add-on additional stuff. And that goes back to suffer and permitted to work.
Yeah, I think it's kind of like what you said earlier, Artie, too, is like you need to have a conversation before they go on that travel. This is what we're willing to, pay you for. Don't open your laptop. Don't answer phones because you're off the clock. We're not paying you for that. So I think it's just having those questions and those conversations ahead of time can really keep you from getting into trouble. Just lay that groundwork for them. I think we're down to just 2 questions. So 48 hours upon terminated and written request. If employee quits on a Friday after the payroll tech already left for the weekend and the following Monday is a holiday, do we have to call our payroll tech to come in and issue that final paycheck?
No, because weekends and holidays would be excluded from it.
So just that next following work day would be fine.
It would be that Tuesday, yes.
Last question. If an employee is being sent to take job-related training classes in another location, that is a 3-hour drive each way, do we pay them for their time driving back and forth? The employer
Yes,
is paying for the classes, meals, motel. So the employer is paying for classes, meals, motel, everything.
everything, yes. They do. And that's why, to alleviate sometimes, we'll ask an employer, just go ahead and let them know the travel time is be paid a little bit less, whatever you have to do, because I know everybody has their budgets, but just make it clear what you're going to be willing to pay for.
If you set a limit on the overtime hours an employee can add to their comp bank, and they continue to try adding to the bank once it's at the limit, are we required to pay them for that overage? They have been instructed to self-monitor and timekeeping systems give them a warning when they're close to the limit. So do they have to pay for that overage?
Yeah, that's going to be a tough one. So one more time on that one, because
Yeah,
was
if
this
you
person a salary-based employee?
Add to their comp bank, continue to try adding to the bank once it's at the limit.
Because they shouldn't have a comp bank.
Okay.
Because comp time is only made available to city, county, state employees.
Okay. So they might be one of those employers. You can call Artie for further information if that was you on that one. I've always understood that salaried exempt employees are working more than 45 hours a week on average. In leadership roles, they're more often than not working around the clock. Time away from the office should be respected as a benefit of all the extra hours they work that are unseen. Why would we want to make them, why would you want to make them clock in and out? Yeah, I mean, yeah.
Yeah.
That was exactly our
I
point.
kind of covered that.
Yep,
Yeah.
for sure. Yeah, I would definitely take a look at that. If you're requiring salaried employees to clock in and out, that kind of defeats the purpose, I would say.
Yeah.
Last one, and then we'll be done, guys. The employer has 48 hours to pay final wages. What if the employees submit a written request for final wage and ask for it within 24? Can we honor 24?
You want to. If you have that ability, yes, of course, but you're bound by the 48.
Okay, perfect. That was a ton of questions. Like I said, these are the most popular. If you still have some follow-up questions, Artie is great about educating you guys as employers and just wanting you to know the information before you get into trouble. So that is what we are here for. Stay tuned. Our next seminar is going to be July 26th, and we are going to have the topic be apprenticeships. So if you've never thought about apprenticeships as a company, you might want to tune in and listen. It's another strategic idea for those who are having trouble hiring. If you have possibly employees within that don't have the skill set, but they have those those social skills and the type of work ethic that you like, and you'd like to be able to get them that training, we have some options for you as employers. So definitely some different options and things for you guys to listen to. Apprenticeships are kind of the wave of the future. So I hope you tune in. Appreciate your participation. It was great today. We love to hear questions and have such a big audience. So thank you from the Department of Labor. And Artie, thank you so much for presenting today.